Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law. Today, of course, we're discussing elder law. You can give us a call, 513-421-4691. Joining Dan Moore and me today, Dennison Keller. How are you?
Very well. Good. Having a good time.
This first 9 or 10 minutes has gone okay?
Very quick.
Okay.
Very quickly.
All right.
You haven't drawn blood yet, so that's a good start.
We'll work on that.
Okay.
That's the third block, so stick around.
Right.
Let's see. We want to get to Bridget in Cincinnati now. Bridget, go ahead with your question.
Yes, my mother needs to possibly go in a nursing home, and I was told to go apply for Medicaid because she does not get enough Social Security. What happens to her bills when she goes in there?
Okay, Bridget, if she is on Medicaid, almost all of her income is going to go to the nursing home. And let's say she makes $2,000 a month with a combination of pension and her Social Security. Most of that's going to go to the nursing home. She'll get to keep only about $40 a month in spending cash to pay for haircuts, personal needs items at the nursing home, and things like that. So it's really important for you to take care of her bills prior to. And to qualify for Medicaid for a single individual to begin with, you have to have your assets down to $1,500. Now that's not income, that's complete assets. So usually as part of that spend down, people will go ahead and pay off their bills and pay off their debts as part of the spend down. If she has more assets than that, and she's already taken care of her bills, one of the things that she can do is set up what's called a pooled Medicaid payback trust, and this is in Ohio. And she could put a portion of her assets into that trust, and the state of Ohio won't count it against her. Now, the drawback to that is the state will have to be paid back out of that trust to the extent they've paid for her care after she passes away. However, in the meantime, while she's still alive, you can actually draw out of that trust to pay for certain kinds of bills that Medicaid's not going to pick up. For example, if she still owns a home, she'll have expenses associated with the home, like property taxes, utility bills. Somebody's got to still cut the grass until they sell that house, and you can draw out of that trust to do so. The other thing you can do with that trust, which is really why it's a great tool, is you have to realize that Medicaid will only pay for a semi-private room, meaning you're going to have a roommate, and most folks at that stage of their life do not want a roommate, correct? So you can draw out of that trust to pay the difference in the private room versus the semi-private room while still being on Medicaid. So it's a really nice tool to be able to use.
All right. I'm sure there's a lot of information that somebody like you would have that there's a reason to come to you at this time of people's lives to understand things like that.
Well, absolutely. And the thing you also have to realize is there's two stages of planning. I mean, there's crisis planning, and that's what Bridget was into right there, crisis planning, in that my mom has to go into a nursing home now, she's got a stack of bills, what do I do? There's also pre-crisis planning, and that is getting in the door prior to 5 years, because there are a lot more options that you can use and employ if you do it prior to actually having to go into the nursing home well in advance. You can protect a whole lot of assets through gifting and whatnot if you come in 5 years prior to actually needing it.
Okay. All right, let's get to another call now. We have Lewis in Cincinnati. Good morning, Lewis.
Hi. I have a question about a living will.
Mm-hmm.
What does that consist of for the people who are taking care of your father?
Okay. Well, a living will is an advanced health care directive. And essentially, a living will is just an end-of-life document. And essentially what that says is that I don't want to be kept alive on machines via artificial nutrition or hydration, breathing tube, ventilator, whatnot, if I am either permanently unconscious or I'm in a terminal state. And your doctors have to sign off on that diagnosis as well. So please do not keep me alive in this state. A lot of folks refer to it as the Terri Schiavo documents. That was the case down in Florida where there was a big battle of whether she wanted to be kept alive or whether, to be let go. So that's what a living will does. That's not going to help you take care of your dad, though. I mean, that expresses his wishes. What you really need to be able to have decision-making authority to be able to do that is called a healthcare power of attorney. And that is not necessarily an end-of-life document. You might just need something in place if you need a surgery that you happen to be unconscious for and you can't give consent for. So a healthcare power of attorney is me designating someone, let's say my child, to go ahead and make those health decisions for me if I am in a position I'm not able to do so.
And all those documents that you're referencing have to be, my understanding anyway, is they have to be executed before the person is incapacitated mentally. Is that right?
That's correct. And it's so important to get these documents done. I mean, we'll give seminars and things like that at nursing homes and healthcare facilities. And at the end of it, I have a slide that I put up, and I say, if you do nothing else, please have 3 things in place: a living will, a healthcare power of attorney, and a financial power of attorney. Because if you don't have these things in place, then if you get to a point where you're incapacitated, no one is going to be able to make decisions for you. And frankly, somebody needs to. So now you're staring down the road of a guardianship. And a guardianship is a court process where you have to go through the court, somebody has to be appointed guardian. If it's guardian over the estate, meaning guardian over the finances, whoever is applying has to have good credit. So if you've got a bankruptcy in your past, guess what? You're not going to be able to be the guardian of your parent. If you happen to live, let's say, in northern Kentucky, and your parent lives in Ohio, and your parent doesn't have a power of attorney document that allows you to be guardian, you're not going to be able to be the guardian of your parent in Ohio, because in Ohio you have to be an Ohio resident. What's more, once you want to start spending money for your parent on health care or to keep up the house or dental work, you have to go to the court and get court approval for every dime that you spend. So it's a really, really cumbersome process that can be avoided if you just do a little bit of advanced planning and get those documents taken care of.
Make the decisions. Just make the decisions.
Right.
Let's go now to Darlene in Amelia. Darlene? Darlene in Amelia? I guess
She went to look to see if she had power of attorney.
she did. She knew that was her answer.
It's an urgent matter.
Right.
Now she has those 3 documents. Let's see. Okay, so we do have another caller here. Kim from Kentucky. Go ahead.
Yes, I was calling. My mother-in-law had passed away, and in her will, she had left property to my husband, and his father is still living, and his name is also on that property. And my concern is he needs to settle this estate, and at this time, it's coming to the point he's going to start getting fined if he doesn't. And I would just like to know what he needs to do in order to settle this.
What would your thoughts be for Darlene?
Well, first of all, I'm not licensed in Kentucky, so I couldn't really speak to Kentucky law per se. I think you'd want to look at the deed. I mean, what condition is that deed? Is it joint survivorship property, meaning did they own it jointly with the remainder going to the survivor after that person passed away? Is it true just a joint tenancy property where one half stays with the living owner and the other half has to be shot down through probate? Sometimes you do have to sell property to be able to settle up the rest of the estate, and it would depend on what kind of other assets are there in the estate.
Okay. All right, we are going to take another break right now. We'll be right back with more law discussing elder law. Stay where you are. Ohio and Indiana bar associations require we give the addresses of the attorneys on the show. So here we go. We have Dennis and Keller with us today. The law practice of Dennis and Keller on Montgomery Road, 513-792-2292. Dan Moore is with us today at the Moore Law Firm on Nimitz View Drive, 513-232-2000. Of course, you can get all this information on fox19.com. Just click on Moore Law. And now, Dan, there was you all handled a case that you wanted to show the viewers a picture and give some explanation.
Yeah, this is a case where we handled involving an elderly man. He was crossing the street, and when he was crossing the street in a crosswalk, he's hit by a car running a red light, and the car runs over his body, and he has a couple broken bones in his legs, injuries to his head and face and mouth. He was in the hospital for a period of time, had surgery. And one of the things that I wanted to remind our viewers is this is something that you can't plan for.
You can't control.
You can't, and it can just happen. And one of the things that was nice about this particular case was that after it was all said and done, talking about elder law, we were able to set up a trust for this man so that his future needs could be taken care of. So this was not a situation where this man was injured and he was never going to be able to recover from his medical bills financially. He had a little bit of a recovery that we could put in a trust and sort of help him through the recovery in the difficult times. So we're talking about elder law, and this applies to about every area of law as well.
Okay, all right, thanks for that. And now we want to get back to the phones. We have Tom in Cincinnati. Tom, you had a question about liquefying assets as we age, is that right?
Yes, I did. I would like to know what the best way to liquefy liquidate your assets as you get older, so that if possible that you have to go into a nursing home. The government doesn't get everything because you don't have any long-term care insurance because it's so expensive. And I would just like to know, if by giving it to your children over years, is that the best way to do it?
What are your thoughts on that, Dennis?
Well, there are two ways for long-term care planning that essentially you can try to protect your assets. One of them he mentioned is buying long-term care insurance. And Ohio has actually incentivized people to do that because, like I said, if you're a single person, you have to get your assets down from Medicaid to $1,500. If you have a long-term care insurance policy that pays out $100,000 over a couple of years, prior to that, then actually it's $100,000 that you get to keep. So that's one of the ways. The problem is it is very expensive, and a lot of folks don't want to do that. An alternative to that is a universal life insurance policy. I call them triple threat policies. They're a life insurance policy, and if you never tap into it, you get a death benefit when you pass away. If you need the cash value, you can draw on the cash, and a lot of these policies then have a long-term care rider, which gives you a little bit of an income kicker to help pay for your nursing home or long-term care. Beyond that, you can try to gift assets. Now, it's really important you don't do this on your own because Medicaid has a 5-year look back. When you apply for Medicaid, you've got to take 5 years worth of bank statements. And what a Medicaid caseworker is looking for is transactions and transfers. They're trying to see if you've gifted your assets, and if you've done so, they will penalize you for it. And in Ohio, the rule of thumb is for every $6,000 you've gifted, that translates to 1 month of Medicaid ineligibility. So if you've gifted $100,000 and then you apply for Medicaid, they're going to say you have to pay on your own for about 16 months. And if I'm down to $1,500 and it's $8,000 a month, how am I going to do it?
Not gonna happen.
So you really have to do this long range. And the best way to do it is to do it into an irrevocable trust. For you, it's the same. It's essentially you're giving away your assets. But the idea is you give it away maybe to a child in trust, and that way if that child gets sued, if that child hits the elderly person that we just saw there, then a plaintiff's attorney can't get at that asset in case you would happen to need it back, and the child could give it back to you. But the hope is that you dump it into a trust, you leave it there for 5 years, and if you can make it beyond that 5-year finish line and not apply for Medicaid, that asset will be protected.
Okay, great. We want to get another call in here. We have Sharon in Delhi. You have a question, as I understand it, about benefits after a spouse has passed away.
Yes, ma'am.
Can you elaborate a little bit on the benefits we're talking about?
Well, what happened was my husband was diagnosed with cancer in 2009. He passed away in 2010, 2 days after Christmas. And we went and had all, before he passed, we had everything set up. We went and got the power of attorney, all the wills, deed upon death. I don't know, there was a couple other things involved. But the lawyer had pointed out to us that on the back of his Medicare card, down to the very bottom of it, it said rights to recover benefits. What does that mean?
And we just have about a minute to answer Sharon's question.
Well, sometimes that might mean, Sharon, and my condolences for your loss, that if there are some medical bills that are hanging out there that have not been processed yet, then Medicare might be able to pick up some of those bills. I'd have to, talk to you and figure out exactly the nuances of your situation, but it could be what that means. I mean, typically, Medicare is not going to transfer from one person to another. You would have your own Medicare down the line when you become of age.
Okay. And Denison, just a closing thought. I mean, and maybe it's those three things. What do people need to take away from this that they need to act on before the decision making is out of their power?
Okay, the first thing you have to realize is that this is unlike the car accident. You know this is coming. I mean, we all age. We're all going to have health issues, so you know it's coming, so keep that in mind and don't wait to the last minute. Number two, again, if you do nothing, make sure you have those financial and healthcare power of attorneys in place. And a lot of folks have think, well, I've got those, and that's great, and that's wonderful, and I applaud you for doing the planning, but you've got to have specific provisions in there to make sure it will translate to protecting assets in a Medicaid situation. Number one, you have to have a gifting power in there. It's a dangerous power to have in there, but what a gifting power is I, as the elder, give you the authority, Deb, to make gifts of my assets. Okay? And number two, to
I
make
need
sure
number 2 and 3 really
there's
fast.
the ability to establish a special needs trust.
Okay. All right, thanks again for joining us.
Sure.
Next week we'll be talking all about injuries, and I'll see you next week.
Go Reds.
All right, go Reds. That's More Law for today. We will see you next Monday.